Good morning, ladies and gentlemen, and thank you, Xavier. And thank you all for sticking around for the final day of the conference, which, as Xavier said, will commence with the discussion on referendums. My name is Jess Keir. I'm a litigation and employment lawyer from Townsville firm Keir Steele Walden Lawyers. Yesterday, former Senator Bob Day mentioned in his tribute to Dr. Nancy Stone that she always enjoyed starting the Sunday session with a little joke. So, in a poor attempt to continue to honour that tradition, let me tell you a quick story about two brothers who loved cricket. They wondered whether they could play the sport when they got to heaven. So they swore to each other, whoever went to heaven first would find some way to come back and let the other brother know whether they could. The oldest brother passed away a few years later, and on the night of his funeral, he reappeared at the foot of his younger brother's bed. "Is there cricket in heaven?" asked the younger brother. "Well, mate, I've got some good news and some bad news," the older brother said. "The good news is, yep, there's absolutely cricket in heaven." "Oh, that's great," said the younger brother. "What's the bad news?" "Well, the bad news is you're opening bowler this Sunday." So it's always a pleasure to descend on the Samuel Griffith Conference each year to hear some of the best speakers in the country, and this year has been no different. An added treat has been to finally get back to the great state of Victoria, in the city of Melbourne, the home of hipsters, vegans, ironic moustaches, and the most lavishly taxpayer-funded netball team in the world. Melbourne, as we know, leads the world in a number of things, including taking out gold medal for the world's longest COVID lockdowns. Now, I come from the cultural and political backwaters of North Queensland, so I don't try to even understand the nuances of Victorian politics. But after months of sending my sad and mad Victorian friends my thoughts, prayers and care packages, you can imagine my surprise when those same hostages repaid my kindness by turning around and voting the captors back in again a few short months later. But it seems as though Melburnians, they don't get bitter, they don't dwell on the past, which is admirable, and they can always console themselves by the fact that Melbourne remains the third most livable city in the world, and is also the capital in the world for sports. It's really the sports capital of the country and sports capital of the world, and nobody can take that away from you, not even Chairman Dan. And I don't know about everybody else here, but I, for one, can't wait for the Commonwealth Games. I just think they're going to be fantastic, and I'm really looking forward to them. But first of all, it's my pleasure to introduce our first speaker this morning, Mr. Paul Jeffries. Paul was educated at Monash University, where he obtained a Bachelor of Commerce in Law. Paul went on to obtain a Master of Law at the University of Melbourne, currently on strike. After commencing his career in private practice at Minter Ellison, Paul came to the bar in 2020. He was previously an associate of the Federal Court of Australia, and he currently practices in all areas of commercial and public law, including constitutional and electoral law, taxation, employment and industrial relations, and migration law. Here to provide some insight into the constitutional limitations on an Australian referendum question, please welcome Mr. Paul Jeffries.
Good morning, everyone. My name is Paul Jeffries, and as Jessica has introduced, I'll be speaking this morning on the constitutional limitations of an Australian referendum question. I thank Xavier and the board of the Samuel Griffith Society for inviting me to speak this morning. That said, I concede what my real purpose is here this morning. I'm told that the effects of caffeine start about half an hour to kick in. So understandably, when Xavier asked me to speak, he said this: Paul, you're on at 9. but the big show is on at 9:45. I don't care what you speak on, just get up there and then get out of the way. Xavier, mission accepted. Thankfully, I have an important topic to speak with you about today. Recently, a legal opinion by the Secretary of the Society, Stuart Wood AMKC, Jacob Patella and myself on the 2023 referendum question has been the subject of some commentary. This morning, I'm going to explain and expand on that opinion. So, the moment for the Australian people is approaching. We expect that it will be the 14th of October when we are each handed a ballot paper like this. And according to this template, which is from the Australian Electoral Commission's website, the ballot paper will state that there is a proposed law and it will provide a description of the proposed constitutional change. And in a small box to the bottom right-hand corner will be directed to write either yes or no, and not a tick or a cross, by the way. My focus this morning is on the referendum question. That is the description of the proposed constitutional change, which precedes the ultimate question, do you approve this proposed alteration? And that ultimate question corresponds with the process set out for constitutional change under Section 128 of the Australian Constitution. Under that section, the success or failure of a proposed change turns on whether or not the electors voting in a referendum, quote, approve the proposed law. Both approve it as a majority of national voters and approve it as a majority of the 6 states. The proposed law here refers to the bill that has been passed by the Commonwealth Parliament, which contains the proposed alterations to the Constitution. As you will know, the first step under Section 128 to initiate constitutional change is for both Houses of Parliament, or in some cases only one House, to pass a proposed law by an absolute majority. And earlier this year, both Houses of Parliament passed by an absolute majority what I'll refer to as the Voice Alteration Bill. Section 128 then provides that once both Houses have passed the bill, that proposed law shall be submitted to the Australian people. The consequence of that is that the power to ratify or veto a constitutional change lies with the Australian people. The test to be satisfied for ratification, the people must approve the proposed law. That is, they must approve the bill. Consequently, under Section 128, the function of a constitutional referendum is a vote by the Australian people into whether a particular bill of Parliament should take legal effect or not. As of today, the Voice Alteration Bill is not law, despite having been passed by both Houses of Parliament. It remains a proposed law which will only obtain legal effect with the approval of the Australian people. So, in March this year, the Prime Minister stood before the nation to unveil the proposed constitutional change in 2023. He expressed that Australians would be asked a simple question: a proposed law to alter the Constitution to recognise the First Peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. Do you approve this proposed alteration? As the Prime Minister says, this is indeed a simple question. But in my opinion, the question may be too simple for its own good. And I'm going to give you my view this morning on 2 broad points. The first is to explain my view that there are limitations on the power of the Commonwealth Parliament to frame a referendum question. Since Federation, there is yet to be a case in which a party has challenged the validity of a referendum question. And in my view, that's most likely the product of the fact that on the 8 occasions that a referendum has been passed, there has been no major political party opposing that change, and therefore, practically speaking, there's been no obvious contradictor to the validity of the question. But in my view, the text of Section 128, considered with its drafting history, demonstrates inherent limitations upon Parliament with respect to the framing of a referendum question. And I'll explain why that's my view. Applying that premise, my second point is that the 2023 referendum question, considered alongside other settings for the vote, is, in my opinion, susceptible to legal challenge. And that challenge may occur before the referendum, or it may occur after it. So, taking those 2 points in turn, let's start with the first point. I'll start by giving a brief overview of the drafting history of Section 128, because it assists us to understand the design of and the values underpinning the process for constitutional change under that section. The drafting history between 1891 and 1900 in relation to the alteration clause that becomes Section 128 reveals a triumph for the Australian people and their direct participation in constitutional change. The earliest drafts of the Constitution did not involve the Australian people voting on a proposed amendment. Sir Samuel Griffith, after whom this society is named, was the head of the drafting committee at the 1891 Sydney Convention. His draft did not involve any popular vote. It instead required the establishment of state conventions, the majority of which had to ratify a proposed alteration before it became law. And this position was inspired by the US Constitution. Article 5 of the US Constitution then provided, and continues to provide today, that a proposed amendment to the US Constitution could be ratified in one of two ways, either by 3/4 of the state legislatures, or alternatively by 3/4 of state conventions. And Griffith proposed to adopt the use of conventions in Australia. However, the use of conventions were fiercely opposed in the 1891 debate by a noisy minority of delegates, including the Victorian Alfred Deakin and the South Australian Thomas Playford, each of whom preferred aspects of the Swiss model of constitutional change. Under the Swiss Constitution of 1874, a proposed partial revision of that document would take effect if the majority of the Swiss citizens casting a vote affirmed that revision. In 1891, though, Griffith had the numbers at the convention, and the state conventions were affirmed in the draft endorsed in that year. That position changed, though, at the 1897 Adelaide session. A new drafting committee, headed by Edmund Barton, was appointed, and relevantly was aided by Barton's assistant for the drafting process, a 30-year-old Robert Garran, who had, shortly before the Adelaide session, written a book entitled The Coming Commonwealth. In that book, Garran, amongst other things, criticised the use of state conventions and promoted the benefits of the Swiss model of constitutional change. And to make a long story short, with this turning point, the alteration clause endorsed in Adelaide and thereafter endorsed in the Melbourne session of the convention in early 1898 contained the substance of the essential features of what is now Section 128, that is, ratification by the people of a majority of the states and a majority of the electors voting. And each of these features were inspired by the Swiss constitution then in force. The upshot of the alteration process designed by the framers of the Australian Constitution is direct sovereignty over the constitutional text resides not in elected officials, but in the Australian people themselves. So, for instance, in the 2004 High Court decision of Singh, the president of this society, Ian Callanan, then a justice of the High Court, said that the power to effect constitutional change resides exclusively in the Australian people and is not to be usurped either by the courts or the Parliament. Further, whatever your view may be on the High Court's jurisprudence on implied voting rights and the implied freedom of political communication, each of those implications are necessarily founded on the foundation, the notion of popular sovereignty. In the 2015 High Court decision of McCloy, for example, the High Court's now soon-to-be Chief Justice, Stephen Gageler, observed how the implied freedom is necessary to preserve the integrity of the method of constitutional alteration under Section 128. So how does this drafting history aid our interpretation of Section 128? As I noted, one of the essential features of the section is the method of ratification, by which the Australian people must approve a particular Bill of Parliament with particular proposed alterations. However, at the same time, the section also says that the vote in a referendum shall be taken in such manner as the Parliament prescribes. So, one argument might be that the latter phrase enables the Parliament to frame whatever referendum question it wants, because that forms part of the manner in which the vote is to be taken. And in my view, that argument is incorrect. Firstly, that view, if it's stretched to its full extent, is inconsistent with the purpose to which Section 128 is directed. The purpose of a referendum question is to ascertain whether the Australian people approve or disapprove a particular bill with particular proposed alterations. A question that fails to serve that function is incompatible with the Section 128 process. And for similar reasons, that view that Parliament has absolute power over a referendum question, in my view, mischaracterises and misapplies the scope of Parliament's legislative power according to the text of the Constitution itself. The reference in Section 128 to Parliament prescribing referendum procedure does not itself confer legislative power on the Parliament. That reference is instead picked up by the heads of power in Section 5136 and 5139 of the Constitution. But these heads of power, read with Section 128, do not empower Parliament to hold any type of referendum that it wants to hold. It only empowers the Parliament to prescribe the manner of the vote that adheres with the essential character of a Section 128 referendum. So, while these heads of power provide the Parliament with deep legislative power with respect to the referendum procedure, the breadth of that possible power is confined to those procedures that are compatible with that essential character. So, let's look at a basic example. Let's say that the substance of a proposed bill to alter the Constitution is to provide the Commonwealth Parliament with a new head of power with respect to subject matter X. But the title of the Act, and also the question, erroneously, and therefore misleadingly, describe the purpose as instead to provide Parliament with a new head of power with respect to subject matter Y, which you can assume for these purposes has no connection with X. In this scenario, the framing of the title and the question undermines the purpose and function of a Section 128 referendum, which is for the Australian people to express their political will in relation to the proposed alteration in the bill, not express their will in relation to a misleading summary of the bill inscribed on the ballot paper. Now, clearly, this is an absurd example and is unlikely to arise, but it shows how there must be limits on Parliament's power to set a referendum question if that vote is to have the capacity to support constitutional change. In particular, it shows how it's no answer in itself to say there's no problem with the question because it merely incorporates the title of the bill. In principle, of course, Parliament can entitle its bill however it see fits. However, if the bill is for the proposed alteration of the Constitution, and if the bill's title is the mechanism on the ballot paper for ascertaining the approval of an elector to the bill's content, then the title must substantially correspond with that content, it must not mislead the elector, and it must not, by material omission, bias a particular response. To do so would be repugnant to the purpose and function of Section 128. And if the validity of that referendum were challenged in court because of the misleading nature of the question, there are two ways in which the invalidity could be characterised. The first involves a reading down of legislation, which is to say that Parliament's legislated rule on the form of the referendum question is invalid insofar as it permits an incompatible question. In other words, there may be nothing inherently wrong with the prescribed form of the ballot paper in and of itself, but insofar as the statute purports to authorise the description of a proposed law in a matter incompatible with Section 128, that statute will be invalid. A second way that the invalidity could be characterised involves the direct application of the Constitution itself, namely that an affirmative answer, an answer of yes, to the incompatible question cannot and does not constitute approval of the bill for the purposes of Section 128. So, in my previous example, an elector might write yes or tick in response to the question referring to Y, but this cannot possibly constitute approval of a proposed law regarding X. In that case, any purported constitutional change on the basis of the incompatible question is voidable by the High Court. So, my example of X and Y may be a clear example of incompatibility of a question, but there will be cases where the line is more difficult to draw. So what about this example? Let's say that the substance of an alteration bill is that for the symbolic purpose of recognising A, the bill will establish a new body B and vest that power with the express power to do C. But the title of the bill and the ballot paper question whilst referring to the recognition of A and the establishment of B, does not refer to power C at all. And on top of this, what if there were reason to suspect that Parliament had framed the title in this way because the symbolic power of A would be very popular with the Australian people, but focusing on the new powers to do C would diminish the prospect of the people approving the alteration? Would that question be incompatible with the purpose and function of section 128? So let's turn to the 2023 referendum, and my view that the referendum question is open to legal challenge. But before I turn to the question, it's important to first frame the lens through which the question ought to be analysed by the court. When the court considers the referendum question, it ought to read it through the eyes of those who have little awareness or engagement with political affairs. If you are here in the room today at the Samuel Griffith Society conference, or if you are later watching a recording of this talk, you are engaged with the Voice debate. But it's likely that a majority of Australians either have no grasp or little grasp of the implications of the proposed law that they are now being asked to approve. One of the tools that is designed to remedy this lack of understanding is the referendum pamphlet, one copy of which is to be mailed to each address on the electoral roll prior to the referendum. And that is better than nothing, but it's no panacea. A survey showed that at the 1999 referendum, only 51% of respondents said that they had received and read at least some part of the pamphlet. But that still leaves a significant chunk of the country that either did not receive the pamphlet or did not read it at all. In addition, the rules for the referendum vote in 2023 are such that there is no safeguard to ensure that voters have had the opportunity to be informed of the Voice Alteration Bill at the time of voting. It's likely that in most cases, any concern with the accuracy or the misleading nature of a referendum question would be extinguished if voters were provided a copy of the bill or a copy of the referendum pamphlet at the time of voting, because that way a court could reasonably conclude that the voters were sufficiently informed or had the opportunity to be informed of the bill that they were being asked to approve. But under current legislation, that won't happen. Voters will only be given a ballot paper with the summary of the Voice Alteration Bill. And what that means is that the framing of the summary of the bill on the ballot paper is critical to the fulfilment of the function of a Section 128 referendum. And in my opinion, there's a realistic prospect that the 2023 referendum question is incompatible with the constitutional process set out in Section 128. The immediate deficiency is with the question's description of the Voice Alteration Bill is that it fails to refer to the Voice's sole function expressed under the bill. It fails to state that its function, its core function, is making representations to the Commonwealth Parliament and executive government. That is despite the function being perhaps the primary reason for the Voice's proposed existence in the first place. So if we look at the explanatory memorandum to the Voice Alteration Bill, it describes the Voice's representation-making function as a key component of the bill. The explanatory memorandum describes the rationale for the Voice's proposed core function as follows, quote, Aboriginal and Torres Strait Islander peoples do not presently have a guaranteed body to provide views to the Parliament and the executive government about decisions, policies and laws that affect them. By addressing the need for such an institution, the proposed constitutional amendment provides a form of recognition that is practical and substantive, end quote. That is, if I was to summarise, it does something more than merely recognise in a symbolic fashion the First Peoples of Australia. It does something more. Now, if we accept the premise of the bill that there is the need for an institution with the devoted function of providing views on behalf of a class of people, and if we accept what the explanatory memorandum says, which is that a key component of the bill is the Voice's core function of representation making, why isn't that function referred to in the summary of the bill on the ballot paper? In my view, the consequence of this omission, not referring to the core function, is that the question at present misleadingly emphasises the notion of constitutional recognition, which receives strong support, instead of the very reason for the new constitutional body's existence, representation making on behalf of a class of people, which has been the subject of division in the media and the community, and appears to be one of the reasons why the Voice proposal has received weakening support this year. There's another reason why the omission in the referendum question of the Voice's only express function is so important. It is because a body of the nature of the proposed Voice is foreign to Australia's historical constitutional framework. It's not like, for example, a new court. And even more than that, a voice, a concept of a voice, has no objective meaning in law. So, to the politically unengaged voter, a legal entity called a voice does not have any settled meaning at all. And if that voter is taking his or her role as a voter, his or her duty in good faith, and wants to know what a voice is and what it means, they're not given a copy of the bill, the thing they're supposed to be approving. They're not given a copy of the referendum pamphlet, and instead they're given a description of the proposed constitutional change, which does not refer to the body's only express function under the bill, which does not explain what a voice is or what it is meant to do. And in my opinion, that series of conditions surrounding the vote invites the risk of the High Court declaring that any purported constitutional change arising from these conditions is void. Now, in circumstances where there hasn't been a High Court decision on this particular issue, it's difficult to predict where the line of invalidity will be drawn. But in my view, the 2023 referendum question is dangerously close to that line and may have gone over it. If I were an advocate for the yes case, I would be urging the government to amend the question or otherwise give voters further detail about the voice at the ballot box to ensure that any majority yes vote is not open to legal challenge. The government, in my view, should not be inviting this legal risk when the solutions to address it are so simple and the costs of the risk eventuating are so high. if you are the government, why invite the risk of trashing years of hard work by advocates for constitutional change? Why invite the risk of a constitutional crisis surrounding the validity of the vote? Why invite the risk of having to spend another $364 million on a referendum do-over? And I'll finish now on this broader point. Just put aside the legality of the referendum question for a moment. In my view, there are deeper lessons that we can draw from the history and purpose of Section 128 of the Constitution. The great advancement of the Australian nation since Federation is in no small part because of the constitutional framework adopted by our predecessors at the end of the 19th century and with only minor changes maintained throughout the 20th century. We should be proud of Australia, and we should be proud of and protective of its constitution. The standards in Section 128 promote constitutional certainty, which provides society the conditions to flourish. The standards of Section 128 need to be jealously protected and enforced. As His Honour Justice Callanan said in the 2003 High Court decision of Marquette, Section 128 is a provision requiring compliance with a strict process for its operation. And for both this generation, the generation of the 2023 referendum, and for the generations of future referendums, it's crucial for those who care about the integrity of the Australian project, for those who seek to uphold the Constitution, to guard against an erosion of those standards. Thank you so much for your time this morning.
Well, thank you very much, Paul, for that insightful paper. We do have time for questions. I might start with the first one. It may be a silly question, but if such a challenge were to be made, would it have to happen in the next 6 weeks before the question was put to the public? I don't really see any utility in making a challenge to the validity of the question after the people have voted either way. It would be sort of political suicide for anybody. And is there any prospect of that happening, do you think? Is this something that is being tossed around and perhaps considered?
Thanks, Jessica. The question could be challenged either before or after. There are means to do it both ways. So taking your question from a legal perspective, there are grounds to challenge it beforehand. One way of doing that would be to file a writ of summons in the High Court and to seek an answer to a special case that, for example, the law setting out the referendum ballot paper is invalid to a certain extent. That's one way. Or otherwise that an affirmative answer to the proposed question would not constitute approval of the voice alteration bill for the purposes of Section 128. So that's broadly the process before a referendum. Afterwards, there is a Court of Disputed Returns process under the Referendum Machinery Provisions Act. Now, the practical unlikelihood of that happening derives from the fact that the only parties given standing is the Commonwealth, the states, the two main territories, and the Australian Electoral Commissioner, none of which I venture to guess would be challenging a successful yes vote. That said, there is probably still room for a residual room for a challenge to the constitutionality of the law itself. Now, so that's a broad overview to how it could happen. Whether it could or might happen practically, I don't know. Litigation of this kind is expensive. and you need to find that the right plaintiff, the interested plaintiff. It may be something that those out there who are concerned with a yes vote might be thinking about, but I'm not aware of anything myself.
Yeah. Thank you. Thanks, Paul. We've got a question at the back of the room there. The gentleman with his hand up.
Thanks for that presentation, Paul. David Stevens. My question is just related to the answer to the question, which has come up in this past week that I thought you might like to comment on, and how that would fit into a challenge of validity of the question. Namely, if you had a result where you had yes was in the yes box, accepted, and then ticks or other indicators of intention, as the electoral commissioner says, might also be accepted, and that were to tip the outcome, change the outcome, how would that flow into the question of the validity of the outcome of the vote in the question?
So if we take the premise that these form of votes could tip the referendum either way, so if we accept that, and it's probably unlikely because that class of ballot papers ticked is probably only going to be a small class or crossed, whether the circumstances may be, but assuming that it would tip the election the referendum either way, the proper process is through the Court of Disputed Returns, which is the High Court. There's a process set out in the Referendum Machinery Provisions Act for the challenge of the return of a referendum, in part either the states or as a national characterisation, but you would need to be pretty quick to challenge those issues. There would need to be eagle-eyed scrutineers ready to raise those issues. But in theory, at least, if there's a set of ballot papers that are open to question, such as the crosses, does it mean no or not? That's the process by which it would be challenged after the referendum.
We have a hand up just down the front here. The gentleman down the front. Thank you.
John Bryson. If there were an issue whether the ballot paper or the information immediately available to the voter when casting the ballot were misleading, would not that open up evidence of all the information available to the voter, additional to the terms of the documents, that is to say, evidence of the entire history of the controversy and of all public debate that had preceded taking the ballot, as large a litigation as one could well imagine?
Thank you, John. It's difficult to know how a proceeding in the High Court on this issue would play out because it hasn't happened before. But one of the counterpoints that would be made against a challenge to the referendum question is that the Constitution, Section 128, provides for this time period, between 2 months and 6 months after the passing of the bill by Parliament, for there to be debate. And the founders of the Constitution deliberately set that period so there would be a period of education, let's say, for the Australian people. And it's possible that those defending the validity of the question would raise what information has been provided, what nature of the debate there has been, but it does raise the question of, well, what does the court consider and what won't it consider? And clearly it can't consider everything that has been said about the debate on Twitter or whatever it be, so there must be some limit to that to constrain the litigation, and it's difficult at the moment without having had a precedent to see where that line is drawn.
We've got a question over here, yes?
David Bennett. Is one argument which could be used for the invalidity of the ballot paper the fact that voice is spelt with a capital V? Now, I'm serious. One of the arguments for the defenders would be that everyone knows what a voice is. If you give a group a voice, you're giving it the right to make representations. But the answer to that is, giving the word voice a capital V suggests that it has some special meaning different from its ordinary English meaning. And that might be argued, is an additional reason why the ballot paper makes it invalid.
You're spot on. The point that I raised earlier is that if somebody is taking their duty in good faith and wants to know what this thing is, there's nowhere to explain what it is and what it's going to do. And you're quite right, the referendum question refers to the voice, capitalised V, capital V, V. It's an entity, it's a thing, but what is this thing? It's not a voice generically, it's a particular new body, we know, and it's unexplained on the ballot paper what it is and what it does.
Thank you. We might take one more question. Up the back, the gentleman.
Nicholas Arona, University of Queensland. Just in terms of the government remedying the problem, I wonder if you could comment on that, because my thought is that it's not enough to make an administrative change to the actual question, because the question has to identify the bill, and therefore it has to identify the bill by reference to its title. So the title needs to be changed. Is that your view?
Thank you, Professor. Not necessarily. What could be changed is the form of the prescribed ballot paper in Schedule 1 to the Referendum Machinery Provisions Act. So the Parliament doesn't need to pass the voice alteration bill altogether again. It just needs to make an urgent change to the form of the ballot paper. Now, how that's implemented could be done in a number of ways, but as you quite rightly note, at the moment the ballot paper incorporates simply the title of the bill. The crux of what I'm saying is that that process, that requirement, is to some extent could be incompatible with what Section 128 requires.
Can you all join me, please, in thanking Paul?